everyone. Today we have with us Anita Vaivade. She has headed the Latvian delegation to the UNESCO Intergovernmental Committee for the Safeguarding of the ICH. She joined the global network of ICH experts in 2007 and cooperated with the UNESCO Secretariat in Paris as a consultant. She currently heads the UNESCO ICH Policy and Law Department, established at the Latvian Academy of Culture, and implements the postdoctoral research project Intangible Cultural Heritage as a resource for sustainable development in Northern Europe, rights-based approach. Thank you so much for being here with us, and I give you the floor, Ms. Vaivade.
Thank you. Thank you indeed. I would like to thank, first of all, the University of Rome, Unitalma, Sapienza, and Professor Pierluigi Petrillo, and you and all the colleagues for the possibility to be here and to contribute to these different exchanges that we might have around the 2003 convention and experiences we've had in different countries regarding the implementation of this particular convention. So thank you once again for the invitation, and I'm going to touch upon a recent history in the legal and policy developments around intangible cultural heritage in Latvia. And this is mainly the question that I'm going to pay attention to in the coming time we have together. So when I say recent history, I really mean concentrating on a history since the re-establishment of the independence of Latvian state. If we try to see back into the history altogether around intangible cultural heritage policy and law, we might look back even to the early years of the 20th century, when was the first period of Latvian independence, namely between approximately World War I and World War II. And also in that period, there were policies and laws which were in the field of intangible cultural heritage, although we didn't name it that way at that time. But I will, as I said, concentrate on the period since re-establishment of the independence, which started with the Declaration for the Restoration of Independence, signed back on the 4th of May 1990. But in fact, the full re-establishment of independence took more time, and we date it a year later, 1991. At that time, and in the name Declaration, there was already attention paid to the importance of cultural rights. As we read, for instance, in that same document, then signed back in 1990, it was also intended to guarantee social, economic, and cultural rights, also political freedoms, which conform to generally acknowledged international norms of human rights for the citizens of the Republic of Latvia and citizens of other countries who are permanently residing in the territory of Latvia. So why I cite this in particular, it's namely to show that the interest and care for cultural rights has been there from the very beginning, since the re-establishment of independent Latvian state. It has been also a core interest quite soon after, when a separate chapter was added to the Constitution, and that was namely a chapter on the fundamental human rights. And also there we see interest and care for cultural rights to be very much present. For instance, as we read in the article 114 of our Constitution, named Satversme, I cite, persons belonging to ethnic minorities have the right to preserve and develop their language and their ethnic and cultural identity, end of quote. So that is, again, a different example where interest in and care for cultural rights is very much present. Why I say this, it's namely to give a broader context within which intangible cultural heritage legislation was later developed. And this context has been quite fundamental for various reasons. So it has given possibilities, the re-establishment of independence has given possibilities for further sovereign legislative processes. It has also re-established, more generally speaking, respect, protection, and fulfillment of human rights. And also it has built necessary frameworks for having a democratic process possible to take decisions upon legislation, upon policies, and to adopt respective instruments also, including in the field of intangible cultural heritage. Furthermore, this experience of national history has been important also in the way certain decisions have been taken with regard to intangible cultural heritage. And I believe that it also helps to explain why certain path of policymaking has been chosen and why certain legislative choices have also been made. So with this introductory notes being said, I will now move forward to really trying to see how the UNESCO 2003 Convention for the safeguarding of the intangible cultural heritage has been implemented in Latvia. And I will continue then on this particular legislative and policy path. Again, for a bit of a context, Latvia joined UNESCO as an organization in 1991. So we might say that that has been done immediately after the re-establishment of independence, and when really decisions on multilateral cooperation on culture, education, science, and other fields were possible again. And Latvia, together with other Baltic countries, namely Estonia and Lithuania, were also among countries who were very much interested to respond to a UNESCO program that was launched already back in 1990s, and that was namely UNESCO Masterpieces program and proclamations of different elements as masterpieces of oral and intangible heritage of humanity. And Latvia, together with Estonia and Lithuania, nominated Baltic Song and Dance Celebration and its tradition and symbolism as an element to be proclaimed. And it was indeed proclaimed as such back in 2003. That was the year, as we know, when the UNESCO Convention was also adopted. And this Masterpieces program and this particular proclamation of the Baltic Song and Dance Celebration has also been decisive when we look at the national legislative and policy processes that followed. And namely, reference to this particular proclamation of the Baltic Song and Dance Celebration as a masterpiece was a reference that was used in a legal text in Latvia, adopted 2 years later, namely in 2005, when a song and dance celebration law was adopted. And it was adopted with a purpose that was defined in its first article, namely, and I quote, to preserve, develop, and pass on to future generations the tradition of the song and dance celebration. So this law was mainly aimed to securing continued policy support, including in the form of funding, but then also speaking about administrative and institutional structures to be established, and be that at national, regional, or local levels. And all of this was really intended for securing favorable conditions for the viability of this particular tradition. At the same time, having adopted a separate law on a separate tradition, it did not in any way put under question the freedom of participants, either to participate in different amateur groups, be they amateur choirs or amateur dance groups or amateur theaters or other, which are involved in the tradition. But this did not put in question, as I said, the freedom either to participate or not to participate in the celebration. And this whole process where governmental support has been provided for, it really culminates every 5 years in a nationwide celebration. But what was also, nevertheless, that came along having established that kind of particular system of support, it necessarily also influences the practice itself. For instance, be that through the form of, as I mentioned, governmental support, including in the form of subsidies to amateur groups, or through providing certain expectations for quality of performance, or also designing upon a common repertoire. So all these different aspects, in a way, influence the practice of the tradition and need to be considered from a quite critical perspective, and engaging different society members in reflecting upon how the system is sustained and what influence it exercises on the tradition and the way we want to see it in the future. So that sort of critical reflection is continuously needed also in the years to come. But having drawn a bit the picture of this particular case when a law has been adopted on one particular tradition, I will now pass on to picturing a broader view on the implementation of the named 2003 Convention. So Latvia joined 2003 Convention rather early. A law in that regard was adopted back in 2004, and so Latvia was among the state parties to the convention, where it really entered into force already in 2006. And Latvia was also among the first countries who considered it important to nominate elements for the international list of intangible cultural heritage in need of urgent safeguarding. And at that time, that was also necessarily a decision that was grounded on the wish that was there from the respective community. And I'm speaking namely about the nomination of the Soiti cultural space to the named urgent safeguarding list. Soiti cultural space was inscribed back in 2009, which was the year of the first inscriptions on that particular list. And Soiti cultural space is still on the list already more than a decade later. So we still, in a way, need to continue to put all the efforts in cooperation with Soiti community to see how to strengthen all the diversity of cultural traditions which are there in Soiti cultural space. And then there were, of course, also processes that were taking place at national level, slightly before accessing the 2003 Convention, and certainly and even more intensely after having taken that decision. And these processes around the national implementation of the 2003 Convention, of course, involved debates around policy developments. They involved also terminology as a matter of discussion. And this, I believe, has been an aspect that is very much discussed in different countries and in different languages whenever the legal term of intangible cultural heritage was faced to different contexts and different also linguistic practices that have been existing. So that was also the case in Latvia. And when I had the chance to participate in these processes, including the processes of drafting the initial texts on intangible cultural heritage intended to become a law, intangible cultural heritage law, I also observed that there are different reflections and different arguments behind reasoning why such a law at national level would be needed. And I would like to propose four such aspects for consideration, or highlighting the diversity of reasons which were already expressed at that time when draft law was still under process of being elaborated. So firstly, I could say that there was an opinion where adopting a law was seen as a valid reference for policy implementation. And that was mainly seen so from the side of different state and municipal institutions, where a law would, in a way, be used as grounds for further policy steps. Secondly, and that was much broader and, in a way, a societal opinion that was there expressed from various members of society, saying that having a law on intangible cultural heritage might also serve as a testimony of value, seen so by communities practicing intangible cultural heritage. In other words, opinions were expressed that if we would have attention, legislative attention, paid to intangible cultural heritage, that would, in a way, show that we pay equal attention to this part of heritage, as we do also for the tangible side of heritage, be that movable, immovable, documentary, or other. So that was also a very strong opinion back then when discussing the possibility of having a separate law. Thirdly, there was also an opinion saying that having a law would serve in a way as a promise of support, namely thinking about institutions and organizations involved, be that, for instance, research institutions, be that non-governmental institutions from the side of communities or other. And that need and support for institutional and organizational work was also very much present in the discussion. So that sort of function of law as not only as promise, but then putting that into practice was seen as something important. And finally, as a fourth observation regarding these different reasons, there was also a view saying that the law might serve potentially as a reference for defending certain community rights and interest in safeguarding their heritage. And as we will see in a minute, this also really came through in terms of definitions of different articles put into the law, although we are still waiting, let's say, how these different formulations will have consequences in practice. But in any case, the expectancy to have this law as a reference for defending community rights, that was also strongly present in the discussion. So finally, a law was adopted. Intangible cultural heritage law was adopted back in 2016. It took a very concentrated shape, if I could say so. It includes 12 articles. And this same law is also very much serving as a ground for national inventory making. But before I give more of an illustration of how the national inventory of intangible cultural heritage looks like, I would wish to give some more characteristics regarding this particular law. And as I mentioned, that this law can indeed serve as a reference for certain community rights protection, it comes from certain formulations that have been provided in this legal text. And namely, some of the specificities to mention is that first, it provides a certain definition of heritage community. Secondly, it also speaks about the rights of heritage communities. And here in particular, it talks about right to the name of the element. It also speaks about the right to the reference to the name of the element whenever the element is used for economic or other reasons. And it also speaks about the rights to information about the element, which all are belonging to respective heritage communities. There is also another additional nuance that sometimes attracts a certain interest, and that is but we might call also as a certain reminder, namely, in this particular law, it has also been said that communities have the right to refuse to participate in certain measures of safeguarding that would be developed by external actors or by other persons, be they measures developed by governmental or local authorities or any other organization. So this possibility to not to participate in certain measures has been something that we are reminded about through this particular legal text. But let me come to the National Inventory of Intangible Cultural Heritage. As I said, inventory which is grounded on this particular legal text adopted in 2016. But if you recall from the beginning of my presentations, we have already 2 nominations on international lists, one on the representative list, namely Baltic Song and Dance Celebration, and the other on the urgent safeguarding list, namely Suita Cultural Space. So that was the situation already at the moment when the law was adopted in 2016. In other words, it is already stated in law that these particular 2 elements are already forming part of the inventory to come, and further steps are already then based on this particular law adopted. So further work with the inventorying of intangible heritage in Latvia was undertaken in 2017, and since that time inscriptions on the national list are taking place twice every year. There was also a National Intangible Heritage Board, consultative board established involving persons from communities, non-governmental organizations, scholars, also representatives from national and regional authorities. And this consultative body is the one who is advising on the decisions to take regarding different nominations for the national inventory. So the national inventory is also a nomination-driven process where all the initiatives are to come from communities, be they bigger or smaller. Up till now, there have been altogether 34 different elements inscribed on the national inventory, and there's quite a diversity of the cultural expressions which are there currently on the inventory. And just to give as an illustrative examples, naming some of these, we might say that there are, for instance, psalm singing in northern Latgale region on the inventory. There's also traditional timber rafting skills on the Gauja River, making patterned double knit mittens in Massalatsa, or also glass blowing craft skills in Līvāni. We have also on the national inventory, for instance, Latvian card game called Zolīte, or also folk dance tradition, particularly in the capital city of Riga. And just to name a few among other. But there's one specificity that I would wish to highlight in particular regarding the inventory of intangible cultural heritage of Latvia. And this is the relatively important presence of elements which are named as cultural spaces. Altogether, currently we have 6 cultural spaces inventoried at the national level in Latvia. I mentioned already Suita Cultural Space, which is one of these, but then also there are others. And to give another example, we have also, for instance, Livonian cultural space as part of the national inventory. And that includes cultural traditions related and practiced by Livonian people who has the status of indigenous people in Latvia. So that is yet another example of a cultural space being recognized on the inventory of intangible cultural heritage in Latvia. But these different cultural spaces, they do have quite diverse characteristics. They also, in a way, mean that these elements are with a different level complexity and also different scale of societal engagement behind in order to have that sort of nomination being proposed for the national inventory. So I would say that these are indeed as a separate genre, if I could put it so, of nominations inscribed. But then also the use of the term cultural space really can attract interest. On the one hand, it is not really defined, neither in the system established regarding the intangible heritage inventory, nor more broadly in any other legal text in the Latvian legislative context. However, we see that the term is rather broadly used, and it might have also further consequences. And here I would wish to refer to another law that was recently established, adopted in Latvia, back only in 2021, and that is the Latvian Historical Lands Law. This law was adopted with the aim to secure safeguarding and also sustainable development of regional cultural environment and also cultural spaces. So also in this particular law, the term cultural space is being used, and also with the intention that there would be certain additional support provided for cultural specificity, not only of different regions, but also smaller cultural spaces, that this support would be provided from authorities. In other words, it gives also a certain promise that this law, namely Latvian Historical Lands Law, that was adopted, will lead to certain consequences in terms of support to be provided for local community development. And this is also an aspect that I would like to highlight as an important and strong point regarding this particular other law that was adopted. Namely, it was very much and very strongly grounded in the necessity of local community engagement in taking decisions on different development initiatives, including the field of culture and including the field of heritage. So the implementation of this particular law is now seen very much in junction with the Intangible Culture Heritage Law. And this junction and policies in that regard is still something that national authorities are working on. And it is still to come to see what sort of policy impact and further activities and their results, where this all will lead to. But nevertheless, expectations are already rather high at this point to see this law being adopted from the side of the communities and to see that this could be put into practice. So prospectively thinking, the acknowledgement of intangible heritage safeguarding as being related to and also being as a resource for regional sustainable development of local communities, this might become really as a step forward for strengthening the understanding of heritage in a broader context, and the role of heritage as being very much also contributing to the vision of our common future. So with this being said, and with all the insights into the experiences of Latvia being provided, I would like to thank you for your attention. I would like to invite you to follow further legislative and policy developments in Latvia around the intangible culture heritage. And I also would wish to conclude with what I started off, and namely that on the one hand, it's a very recent history in terms of legislative and policy decisions. And on the other hand, it is very much and substantially grounded in the possibility to take sovereign and independent decisions on how heritage would be to be safeguarded in the territory of the state, and in this particular case in the state of Latvia. And I also believe that every one of us can contribute to see how these different legislative and policy frameworks could be put into practice from the side of our different roles, both professional as well as personal, in connection to intangible cultural heritage safeguarding. So with this being said, I thank you once again for your attention. Thank you.